Hi, folks. We're going to get started here in just a couple of minutes. But while we're waiting to get started, if you'll just make note of those few housekeeping notes on our first slide here. And then I've got 2:30, so we're going to go ahead and get started. Welcome, everyone. Good afternoon. My name is Lindsay Vaughn. Thank you for joining us today. I'm a research and project management consultant at the Pennsylvania Commission on Crime and Delinquency. And this afternoon, we're going to be discussing the research findings of our research team relating to the relinquishment and retrieval of firearms as part of the protection from abuse order process. I'm joined by a few colleagues here today, both internal at PCCD and some of our external partners, and we'll be introducing those folks in just a few minutes. Just a couple of quick housekeeping notes as we get started. This webinar will be recorded and posted on PCCD's website once it's available. We'll also be posting a slideshow, and we'll try to send that out to everyone who we have emails for. I'll note before we get started that we did receive a few questions as part of the registration process, and we're planning to address those as we move through the presentation. But if you do have any questions regarding the presentation, as noted on the first slide, you can contact me, and I'll be putting my email up at the end of the presentation as well. Or you're welcome to contact any of our other presenters if your questions are more applicable to them. So our roadmap for today, our presentation should run for about an hour, give or take a few minutes. We're going to start with a brief overview of the Pennsylvania Commission on Crime and Delinquency, or PCCD, the Pennsylvania Coalition Against Domestic Violence, and our Temple University research team, who are all partners in this effort to study and understand the impacts of Act 79 on weapons relinquishment. We're also going to do some quick level setting before we jump into the research to discuss protection from abuse orders generally, what Act 79 did and its impact on our research, and then just give a little bit of information about the Protection from Abuse database. We'll follow the background discussion with some summary of the research findings in PCCD's report entitled Analysis of Weapons Relinquishments and Protection from Abuse Orders in Pennsylvania 2019 to 2023. We'll offer a few key takeaways for our practitioners out there. And finally, we'll end by providing you with a summary of ongoing research that will continue to help us understand weapons relinquishment as required by the Protection from Abuse Act. So starting with a quick overview of PCCD, the Pennsylvania Commission on Crime and Delinquency was established in 1978 through Pennsylvania state law and serves as the Commonwealth's justice, planning, and policymaking agency. Our mission is to enhance the quality, coordination, and planning within the criminal and juvenile justice systems, to facilitate the delivery of services to victims of crime, and to increase the safety of our communities. We're a relatively small state agency housed within the executive office with approximately 150 employees. We're directed by an overarching commission, which is advised by 7 advisory committees and 2 training boards. PCCD's responsibilities and programs fall into a number of different areas, including funding and grants, technical assistance, data and research, victims compensation, and training, among other responsibilities. If you're interested in learning more about these areas, I'd encourage you to check out our website at pccd.pa.gov. You'll see now some of those areas that we focus on at PCCD, including preventing and reducing gun violence. I'm not going to step through each one of those little squares there, but we do operate in all of these spaces. We are well informed by practitioners in these spaces and lucky to be so. So criminal justice system improvements, law enforcement technology and training, you can see juvenile justice system improvements, and data and research. And I'll talk a little bit now about our data and research team. Our internal research team is actually built through a cooperative agreement with Indiana University of Pennsylvania. So PCCD supports 4 IUP faculty on a full-time basis to serve as research staff, and we handle all manner of research inquiries for the agency. Some of our recent studies, of course, include the one we're here to talk about today, but we also do research on recidivism trends for criminal offenders, both statewide and in individual counties, And we also have done research on long and short-term crime trends. Dr. Brandon Vick is here with me as well on behalf of our research team today. Dr. Vick is one of our part-time research partners, and I'll just turn it over to him briefly to introduce himself.
Hello, everybody. Welcome. I'm so glad to see so much participation. We've been working with this data for several years now, and I hope that you have time to look at the full report. But we're very excited to kind of give you a brief synopsis of our findings and talk about how it leads into the great work that Temple's doing to understand more about what's going on here. So thank you all for being here today.
Thanks, Brandon. And now I'd like to turn it over to another one of our co-presenters, Danny Beinsroth, who is going to introduce herself and discuss the Pennsylvania Coalition Against Domestic Violence.
Thank you so much, Lindsay. And hello, folks. My name is Danny Beinsroth. I am the Legal Services Director for the Pennsylvania Coalition Against Domestic Violence. Most of you folks know us as PCADV. And for those of you who do not know who PCADV is and what we do, we are the first state domestic violence coalition in the nation, and we're established in 1976. And we are a coalition of 59 member programs serving all 67 counties in the state of Pennsylvania. And I specifically work out of the Harrisburg office, but I live in Philadelphia, and I oversee our legal projects, programs, and particularly what brings me here is the Protection from Abuse Database, or FAD, or PFAD, as folks are usually aware of it as, and user requests and general technical assistance and training along with the Pennsylvania State Police. So that's a little bit about PCADV, a little bit about the coalition, and now I'd like to turn it over to Elizabeth Van Nostrand of Temple University to introduce her team and her work on the project as well.
Thanks, Danny. Hi, everyone, and conducting a project to figure out why there are such differences among Pennsylvania counties with respect to the implementation of Act 79. I'll explain more about our project in a few more slides a bit later, and thank you so much, Lindsay.
Thanks, Elizabeth. So before we transition to talking about the research, as I mentioned at the beginning, I want to make sure, we're all sort of level set in terms of what a PFA is and what Act 79 did. Just a brief note, having now had everybody introduce themselves, I did want to reiterate, we'll each have our emails displayed at the end of the presentation if you were to need to contact one of us after the presentation. So in terms of summary, we're first going to discuss what a protection from abuse order is, and then we'll discuss Act 79 specifically and how it sparked our research for this analysis. So I'll ask Danny to talk a little bit about PFAs generally.
Yeah, absolutely. So this is just some very basic, as Lindsay said, level setting around protection from abuse orders and around Act 79. So most folks are very much aware of what a PFA is what we'll refer to them throughout the presentation as, but these are civil protections for victims of domestic violence against a family or household member. Both victims of domestic violence and family and household member are both defined within the Protection from Abuse statute. The victim is the plaintiff or the petitioner, and they are seeking to be protected by either the family or household member, which is the defendant in terms of the captioning and the titling of a PFA. We refer to them as quasi-criminal in nature because they are civil orders that can result in criminal penalties, which we often refer to as an ICC or an indirect criminal contempt, which is each charge is a max of $1,000 fine and up to 6 months in jail. So they are quasi-criminal in nature, and that's how we refer to them. And there are various forms of relief. That is one of the beauties of the PFA Act. It's been around for almost 50 years, and therefore the relief that's offered in the statute is very robust. We have no abuse, no contact. Those are two separate provisions. Oftentimes, folks will be allowed to have contact with an abuser, but the abuser is prohibited from abuse in those cases where the survivor is relying on that abuser for their living conditions or housing them. We have eviction, or otherwise titled as exclusion from the residence, temporary child custody, temporary child support, and most importantly, why we're really here is, and what the changes that are really from Act 79 is the relinquishment of firearms by the defendant. Next slide, please. So this is just a very quick review and look at what the protection from abuse order looks like, the front page. And really, we're going to be talking about one of the most seminal pieces of relief in the PFA Act, which is the relinquishment of firearms, and specifically what rates the weapons are relinquished and retrieved, because relinquishment means they're not just prohibited from, having weapons and possessing weapons, that they need to hand them into a safe agency or third party. And again, this is really the front page of what a final protection from abuse order looks like. And you'll see that the petitioner and plaintiff has the option to check what is in this red box here as the weapons cautions. And that's going to indicate that a weapon was involved in the incident, either present or the property, or that petitioner is requesting that the judge order the relinquishment of weapons in the PFA case. So before we get into the research, I'm going to pass it back over to Lindsay to talk more about the bones of Act 79 that was passed in 2018, and also PCCD's, Office on Gun Violence Prevention. Lindsay?
Thanks, Danny. So Act 79 was passed on October 12th of 2018 and became effective on April 10th of 2019. So we'll have our 6th-year anniversary of the effective date of Act 79 in just a couple days here. At its core, Act 79 made changes to the PFA Act and also to the Pennsylvania Crimes Code relating to misdemeanor crimes of domestic violence. Those changes primarily dealt with safety provisions related to firearms and the rules around relinquishment and retrieval of firearms, and was really designed to help prevent domestic violence homicides. As some of you may know, Pennsylvania is one of 29 states that require the surrender of firearms and other weapons by individuals subject to protection orders or convicted of domestic violence offenses. The aim of these laws is not just in Pennsylvania, but across the nation, is to promote safety in instances such as domestic violence, where we know that the possession of firearms greatly increases the odds of DV-related fatality. Over half of all intimate partner homicides in the United States involve firearms, and in fact, in Pennsylvania, we're a little bit higher than that right now. So just to highlight a couple of the examples of the law prior to Act 79 and after, and I just want to be clear, these are not the only changes that came as a result of Act 79, but these are the ones most applicable to our conversation today and our research. So prior to Act 79, firearms and other weapons could be relinquished if ordered with a PFA by a defendant to any family or household member. The relinquishment, retrieval, and storage of weapons was solely the responsibility of sheriff's deputies in Pennsylvania, and judges had complete discretion in determining whether or not to order firearms relinquished as part of a protection from abuse order. After Act 79 passed, some of those provisions changed. So firearms and weapons can now only be relinquished to that we know judges have more limited discretion in when and how they order firearms to be relinquished. Another note, and Danny's going to talk about this in just a moment, as a result of Act 79, the Protection from Abuse database was updated to provide greater abilities to mark weapons cautions and ensure law enforcement compliance with relinquishment orders. I think one of the big pieces here are the limits on judicial discretion after Act 79. So the court may order the defendant to relinquish weapons as part of a temporary order if certain circumstances are met, that the petition demonstrates abuse was involving a firearm or there's an immediate present danger of abuse. A final protection from abuse order that is entered into pursuant to a consent agreement between the plaintiff and the defendant may also be subject to a relinquishment order, but it's not required. However, any final protection from abuse order that's entered into after a hearing before the court, meaning plaintiff presents evidence, defendant has an opportunity to present evidence, and the judge is the one who's ultimately deciding whether the protection order is going to be ordered, that the court must at that time order that the defendant is subject to firearms, other weapons, or ammunition relinquishment. I'm going to take a moment now here on this slide to talk about one of the questions that we received prior to the presentation. And the question was, can you explain any interactions and interplay between Act 79 and the federal law that says anyone with a domestic violence restraining order cannot possess firearms? So a final PFA order, whether entered into by order or by agreement, is a qualifying protective order under federal law 18 U.S.C. 922 G8. And this does prohibit the defendant from possessing or acquiring a firearm while the order is in effect. So that prohibition on possession remains or exists even if the PFA does not include an order to relinquish firearms. Some of the changes that Act 79 included made this more clearly enforceable under Pennsylvania state law. And in fact, Act 79 was meant to bring PA state requirements in line with the federal requirements under the Violence Against Women Act. Relinquishment here in Pennsylvania is a bit more robust than a ban on possession during the time the order is in effect, but they both work to complement one another to ensure that the restrictions around the defendant's firearms access is similar under state and federal law. And so the provisions of Act 79 work to complement the federal and state requirements for no possession during the time of a protection order. Danny, before I move to the next slide, is there anything you'd like to add there?
No, I think you summed it up quite well.
Okay, great. So this slide is really just a visual representation of what we're talking about here, sort of the PFA process. So over on the far left there, you can see the first step in the process is the plaintiff, petitioner, victim filing for a protection from an abuse order. As we showed on an earlier slide, they may include information right on that very front page of the petition indicating that the defendant has firearms or that they're requesting that weapons be relinquished. At that the first step would be, the petitioner would go before a judge. The judge may grant the order, the judge can deny the order. If the judge denies the temporary order, that process will often end there. However, a hearing may be scheduled for a final order, even if the judge denies a temporary order. If the judge grants a temporary order, the judge may, as we said on a couple slides back, may order weapons to be relinquished within 24 hours. The hearing for a final protection from abuse order must be scheduled within 10 days of the entry of that temporary order, and the defendant must be served, must know that the hearing is occurring, and so the hearing for a final order may be continued once or more than one time before it actually gets before the judge. At that final hearing stage, there are again two options for the judge. The judge can deny the final order, at which point the process would end for the petitioner, and the judge can grant the final order. And a protection from abuse order can be granted in one of two ways. It can be granted by agreement, and that would mean that the plaintiff and the defendant and their attorneys, if they have them, would discuss what the order was going to say, what the parameters of the order would be, and by agreement, present that to the judge to be issued as a final order. If the plaintiff and the defendant do not agree or do not wish to try to agree, then they'll have a hearing in front of the court where evidence would be presented. And if the judge determines that a final protection from abuse order should in fact be ordered, pursuant to Act 79, the judge must order weapons to be relinquished within 24 hours. So again, this is just a visual representation of that judicial discretion slide that we showed a couple slides back. So how did we get to doing this research on Act 79 after its passage in 2018? Well, shortly after Act 79 actually was enacted, citing a rise in gun violence nationwide and in Pennsylvania, then Governor Tom Wolf signed Executive Order 6 of 2019, which tasked multiple state agencies, including PCCD, with undertaking efforts to reduce gun violence. There were a number of provisions in this executive order, but one of them was the establishment of an 18-member special counsel on gun violence and the Office of Gun Violence Prevention within PCCD. That special counsel was ordered as part of its, its responsibilities to study and make recommendations to reduce and prevent community gun violence, suicide by firearms, accidental shootings, mass shootings, and most importantly for our topic today, domestic violence related shootings. The work of the committee culminated in a report of findings, recommendations, and action steps, one of which was examining the impact and implementation of Act 79. And so this first iteration of PCCD's Office of Gun Violence and Prevention was where we were able to find space to start studying the implementation of Act 79. While Brandon and I and our colleagues were working on finalizing the report that we're here talking about today, now Governor Josh Shapiro signed Executive Order 2 of 2024, reestablishing the Office of Gun Violence Prevention at PCCD, which includes an emphasis on data and research and authorizes continued focus on the intersections of domestic violence with gun violence. So while that original executive order allowed PCCD to begin working with data, begin working with the Pennsylvania State Police to collect data from PFAD, which Danny is going to talk about in just a moment, we just got a boost to the authority to continue doing research here. And we're actually, the first iteration of the Office of Gun Violence didn't come with staff or funding, but the second iteration has come with staff and funding. And so we're building that office out now. And the intersections of domestic violence with gun violence is one of the very important items on the research agenda. All right, so one more thing before we get into the substance of the report. I want to turn it back over to Danny to discuss the Protection from Abuse database, which, as I just mentioned, is where the data that we analyzed came from.
Yeah, Lindsay, thank you so much. And yeah, I just want to talk a little bit about PFAD. That's what I'll refer to it throughout today's presentation. But if you say FAD, that's totally fine too. And here is the URL where you can access the Protection from Abuse database. And what it is defined as by the Protection from Abuse Act, which established the existence of PFAD, is it is a registry of all valid temporary and final court orders of protection and court-approved consent agreements. So it is different than a case management system. It is purely a registry with the purposes of informing courts, law enforcement, and dispatch about temporary and final orders. As you will see, we do not put emergency orders into PFAD because, again, their duration is so short in nature that it often are not entered before they go out of effect. PFAD exists because it's very key for survivor and law enforcement safety. Part of one of the things that gets filled out along with order paperwork is the supplemental data sheet. This is a data sheet that takes all of the information of the defendant for service purposes, so that law enforcement knows exactly what that person looks like, can make safe identification, and therefore make safe service, and also retrieve firearms as well too as part of that service. Anybody who works as part of the PFA system can request a PFAD account. However, access levels and what folks are going to see within that database is very dependent on the role. With very few roles being able to see, all of PFA information on all of the filed orders within the state. It's very much limited to what they put in and the counties that they serve. Big important piece about PFAD is that it is, as I said before, we run it in conjunction with Pennsylvania State Police and specifically the Commonwealth Law Enforcement Assistance Network, or CLEAN. Because once a PFA is entered into PFAD, the rules require that prothonotarians are to enter that PFA and data sheet to CLEAN within 24 hours, and that is allowed for on the PFA database. And a really big piece of PFAD is that and why we're here is because it tracks firearms relinquishments ordered in PFA cases. And this next slide, I'll really just briefly explain how PFAD does that. So the way that it starts is when a PFA is filed with the prothonotarian's office. When the prothonotary goes to enter in that PFA into PFAD, they're going to be prompted to select what is called the ORI, or the originating agency identifier. This is both for the petitioner and for the defendant, because even though the defendant may be the only person who is getting served and maybe the only person who is relinquishing firearms, the individual who is the defendant can be charged with a criminal charge in both the petitioner and the defendant's jurisdiction. That originating agency identifier is the police department that will be responsible for ensuring the defendant relinquishes their firearms. So it's defendant's jurisdiction or plaintiff's jurisdiction, and it is identified by this unique number identifier selected within PFAD. PFAD is very smart, and once that ORI is selected and that and that PFA is filed, the system sends out a notice to all of those police departments' accounts within PFAD that there is a defendant who has been ordered by the courts to relinquish a firearm. The agency then acts upon that notice and goes out and retrieves or either gets the weapons from the defendant who brings them in within the 24-hour period to the relinquishment authority. And that relinquishment authority has a PFAD account and will enter in a receipt of relinquishment that summarizes what weapons they either received in that handover or obtained when they served that order. If that receipt is not entered, the agency that receives that non-compliant will receive those notices that's saying that they are not in compliant with the relinquishment requirements every 24 hours until the receipt is entered. Once the 24 hours is up, they will also receive an additional non-compliance notice that is requiring them to go out and investigate the defendant for failure to relinquish firearms, which is a criminal charge. So we did have a question I wanted to just answer it very quickly, is that we were asked is when a relinquishment order is issued to an individual that can legally purchase another weapon, how are they prevented from rearming themselves? So this is exactly why PFAD is linked with CLEAN. So when the defendant is ordered to relinquish and the order is entered into PFAD, when it's sent over to CLEAN, they also enter it into PICS, which is the Pennsylvania background check system, and NICS, NCIC, which is the National Criminal Instant Check System as well. So this will flag when they go to a federal an FFL, Federal Firearms License Dealer, who will have to run that through the system, and any of those specific cautions will pop up because it's been entered through those concurrent databases in that line. So with that being said, that is, I think, all that we wanted to talk about in terms of laying the groundwork for PFAD. And I think it's really time to transition over to Brandon to really talk about the data and the research that was performed on the PFA relinquishments.
Yes, thank you, Danny. So we started working with this data a few years ago and recently revised our report. So just to give you a layout, we were charged with really looking at what is in this data. And the data, as we were going through it, we wanted to attempt to tell the story of cases. Okay, so a case may, it's in the life cycle of an individual case, which starts from the petition and may go through several cycles of temporary hearings and orders, and then may ultimately end in a final PFA order and possibly a relinquishment order and retrieval. So that is the scope of the data we were working with. A lot of the questions we received prior to the webinar related to things that we simply do not have data on, such as characteristics of either the defendant or the plaintiff. So we do not have in this data, race or gender or age. We also do not have other outcomes beyond a final PFA order, such as other sentencing or conviction type outcomes, or much less victimization outcomes. So we're basing the scope on these individual cases that we have data on within the PFAD. So what we do have is a lot of the characteristics that are checked off in the petition, such as the weapons cautions, that when someone is filling out a petition that a weapon was present. We'll talk a little bit about the additional weapons inventory that can be filled out in the time of the petition, which gives an inventory of what firearms or other weapons may be owned by the defendant. We have through if a final order is determined, we'll have information on the relationship between the plaintiff and defendant. And we also know if there is a final order, whether that came about by hearing or agreement or was unspecified. In some places, and for some cases, a final order, it's not indicated in the system whether it came about through a hearing or by agreement. With final orders, we know what the prohibitions are, if it is no contact or no abuse. And then we know with final orders or sometimes temporary orders, whether there was an additional relinquishment order attached to that and a retrieval that came about from those orders. And we know how long these orders are when they expire. So the main thing that we found out, looking at multiple orders that we have combined to cases, we found that since 2019, around May 2019, there was almost 175,000 total cases. So one thing that we try to do is look at different case types. So, and there's two primary ones we want to look at. Those that ended with no final order for a few different reasons listed there. In some cases, the temporary order was not granted. In some cases, the temporary order was granted, but the case was dismissed before a final hearing or the plaintiff failed to appear. Actually, of all the cases, that's the largest subgroup. And then a number have the final order was denied. The second large group, though, is cases that ended with a final order. And we are able to break those down by those granted by hearing, granted by agreement, and again, those granted by some unspecified means. And we'll look at all the data with all those here in a moment. With the limited scope of our research, we wanted to separate and look at different retrieval, final order being granted versus ungranted, retrievals being made, not made, by different case characteristics. So we do some breaking down and reporting on the characteristics that we have, such as the relationship, by the length of order, by the type of relief granted by the plaintiff, and then orders that also include or do not include various weapons cautions. We can really differentiate by that. This was a large data set. As I said, 175,000 cases over the past, almost 6 years. So one of the goals is to look at what's going on over time and looking at growth rates from our first full year in 2020 to 2023. We also wanted to get an idea of the prevalence of this. How often is it happening across Pennsylvania households? So there's a lot of numbers that you'll see, and I apologize, it will be quite a bit of numbers coming at you. But we have lots of rates that we try to break up just to get some sense of what's going on here. And we identified and calculated which law enforcement agencies were carrying out the actual retrievals. So this is kind of our overall table that's showing everything. Okay, so one thing that I would note is along the row that says total. Okay, this is the numbers I laid out before, and if in the kind of near the bottom right, you'll see that there's 175,000 total cases. So again, we're breaking these out by case outcome. All right, and what we wanted to show is there is a certain case outcome growing relevant to the others. Now, one thing, if you look at across the bottom row, that's the growth, the percentage growth in cases from 2020 to the end of 2023. Now, one thing to keep in mind, as of course, as we all know, 2020 was a very different year, and very likely it was a kind of a, especially low year for cases because everything was kind of shut down for a bit over COVID. So I'm not using these growth rates as an indicator of cases. That's the actual overall, as an indicator of overall growth of cases, which seems large because our base year was probably a little bit low. But what we want to do is compare those rates across different types of cases. And what we see is those being granted by hearing were growing at a bit faster pace than those by agreement and of the total number. So overall, cases grew by 16% from 2020 to 23. Cases granted where there was a final order granted by hearing grew a little bit faster, cases granted final orders where the final order was granted by agreement grew a little bit slower. Okay. Now, one thing that we want to point out, we were doing a balance of what's going on statewide with what's going on in various counties. And so this county map, the main thing I want to show here is growth of cases varied widely across throughout the state. And in these darkish green blue areas is where the number of cases actually fell by quite a lot from 2020 to 23. And the darker brown counties are where case numbers actually grew by quite a lot from 2020 to 23. But this map shows that, while at the state level we have one number, there's quite a bit of variability across the state. And that's one key finding we find, whatever rates, if we're looking here, we're just looking at cases. In a minute, we'll be looking at final orders. And after that, we'll be looking at relinquishment orders and retrievals. in all of these statistics, there's quite a lot of state variability, of county variability going on. So that's kind of the main thing. Not everyone looks the same, okay? And there's a lot of differences across the state. So our case prevalence number, again, looking at the comparison going from 2020 to 2023 may not be the best one, since 2020 was an odd year. But what we wanted to do, this was just an attempt to look at how often is this happening across Pennsylvania households. And so I have it per, the typical prevalences per 100,000. One that makes a little bit more sense is maybe per every 1,000 households. So in terms of total cases, we are seeing a PFA case in 7 out of every 1,000 households, or 714 out of 100,000. And over the past 2 years, from 2021, we see that hovering around 7. So I wouldn't put too much into that. In 2021, the total cases were 692 out of 100,000, going up to 714. But the main takeaway from this is this is about the prevalence. And from 2020, it possibly went up, but it's staying about the same over time. So that was a good finding for us to look at. And next slide, please. So in terms of final orders, this is a set of characteristics that we do know. So while we do not know the gender or race of defendants and plaintiffs, we do know their relationship. Okay, and so by far, what we're breaking this down is final by hearings, final by agreements, and final by other means, unspecified means. And we see that across that categorization, predominantly most of these PFA orders occur between intimate partners, with parents and spouses coming in second. One thing that is not in this slide that we did put in the report, one initial finding, is that from 2020 to 2023, most of these relationships stayed fairly stable, except for the 2 child categories. We did see that where there was the biggest difference growing over time is that more often, and again, fortunately, it is still relatively low to others, but more often we are starting to see that this relationship involves children. And so from very small growth to slightly larger growth, we are seeing some growth in that. So that was one thing that we noted in the report that we wanted to people to be aware of. Another characteristic that we do have is when does the final order expire? And again, we have this broken down by whether the final order was by hearing or agreement. One thing that is noteworthy here, among final orders by hearing, those tend to have a longer expiration date. Okay, so the brown graph is the distribution of final orders by hearing. And we see that a larger percentage of those have an expiration date from 2 to 3 years. Compare that to final orders by agreement, where a larger percentage of those have an expiration date of less than 1 year. And these differences are statistically significant, and they are quite large. But that's one thing to note here. So one thing that we really, really wanted to stress is being able to look at the first part of the process, which is the petition, and the outcome of the process, which is, did it end up with a final PFA order? So this table, again, I'm sorry for all the data we're throwing at you. The columns of this table indicate our categories for how the case ended. Did it end with a temporary PFA hearing only, or did it end with a final PFA? Okay. Now, the percentages here in columns 2 and 4 are the percentage of those cases that had within the initial petition that the weapon be any weapons be relinquished. Okay, the key point here is we were seeing a strong growth, whether we started at 2020 or 2021. We're seeing a large growth in the percentage of cases that have that it started off with a petition with that checked off, that weapons need to be relinquished. So we have if you think back a couple of slides when I was talking about overall cases were growing about 16%. Cases with that checked off, indicating that a weapon be relinquished, are growing about 40%. Okay, so this is one key finding that we found, that the growth of these types of cases where the petitioner is indicating that the weapon be relinquished are growing much faster than overall PFA cases. What we find, a second finding here, is if we're comparing the cases that end with temporary hearings to cases that end with a final PFA order, a much larger Next slide, please. Okay, so this one is similar to the previous one. Maybe it's a lot easier to read. But again, what we're seeing here is this is a similar breakdown by our case categories. 33% of temporary, those ending with a temporary order only, had that relinquishment caution in the petition, compared to 53% of those ending with a final by hearing, 37% with a final by agreement, and then 58% of finals that by unspecified means. So what this is indicating is possibly a severity of these cases where when petitioners indicate that a weapon be relinquished, that caution in the petition, a higher proportion of those cases tend to end up with a final PFA order, either by hearing or agreement. So again, not all cases that begin with a petition have that relinquishment caution, because there may not be a weapon in the household, or it may not have been related to the case. What we find here, again, as I mentioned before, there's a large variety across counties. So the statewide numbers are very different from county to county. Here, the counties in brown have a higher percentage of cases where that relinquishment caution was checked off in the initial petition, whereas the darker greenish blue counties have a very low percentage. Now, what was striking to us here is not that counties vary, but that they varied so much. And it seems unlikely at one extreme that only 1% or no cases would have the petitioner requesting a relinquishment. It also doesn't seem likely that would happen in every case in a county. It could be that both of those are possible, but it was just the large variation in the counties was something that we wanted to take note of. And that's what we see here. So despite all that variation across counties, on average, across, statewide, it's about 33%. 33% of cases. Oh, sorry, I'm moving on from relinquishment cautions to actual orders. So what we see here is that of these cases across our case categories, the percentage of orders or percentage of each case where there's also a relinquishment order. Okay, so cases in our first column, cases that end with a temporary hearing. Okay, even though they don't make it to a final hearing, 33% of those cases also had a relinquishment order. Okay, sorry, 35% of those in 2023. So these percentages go down in the second column of that subset of cases where a final order was denied. For cases by hearing that end in a final order by hearing, we see a much larger percentage of those with a final PFA order by hearing also have or ordered to have a weapons relinquishment. So final PFAs by hearing tend to have weapons relinquishment orders at much larger rates. Compare that to those that end in a final PFA order by agreement. These are quite a bit lower. So 41% in 2023 versus 60% in 2023 of those by hearing. So again, if we think back how fast are overall PFA cases growing from 2020, they were growing about 15%. The number of final PFA orders were growing by about 24%. Weapons relinquishment orders that go along with a PFA order are growing by 58%. So our weapons relinquishment orders are growing faster than overall PFA orders. So it indicates this is being utilized even at even greater rates as time goes on. What we're doing here is, again, attempting to compare characteristics from the start of the case to outcomes at the end of the case. Okay, so these weapons cautions, the different sets of bar graphs here indicate different weapons cautions that could have been or weren't checked off in the initial petition. So the first two sets of columns separate the cases by whether the petitioner had checked off whether a weapon was present or not. In the second two sets of columns, the petitioner either indicated that a weapon was involved or not. And then the third set of columns indicate whether the petitioner checked off that a weapon should be relinquished in the petition. In each of these cases, for each of these types of weapons cautions, if they are checked off, those petitions end up as cases that also include a final relinquishment order. So that's the first thing I want to point out here, is that when those indicators are checked off, those cases tend to evolve to be ones that also include a relinquishment order. Just looking at the columns on the right, 98% of the time when a petitioner indicates that the relinquishment caution, that a weapon should be relinquished, 98% of those cases end up with a weapons relinquishment order. The other thing to differentiate here is how we are separating final PFAs by hearing and agreement. Okay, and there is a slight difference. As we indicated before, PFA orders, final PFA orders by hearing have higher rates of also having a final relinquishment order compared to PFA orders by agreement. And we see that across the board here, with the exception of if there's a caution for relinquishment in the petition. Those are about the same, both at about 98%. One other thing that we could break things down by is the weapon restriction that comes in the PFA order. Okay, so we see much higher rates when a PFA order, a final PFA order, is given. At very higher rates, there's also the no possession restriction. Okay, so for instance, 87% on the left side of this slide, 87% of final PFAs by a hearing also have the no possession order. All right. If we move over, and then no license is much lower, but we have those rates there. But compare that to the actual relinquishment order. So 53% of final PFAs by hearing also have a relinquishment order. So while I don't know what's going on, but this may be related to some of our questions, and we initially had these questions ourselves. Shouldn't 100% of final PFAs by hearing also have a relinquishment order? But it seems that while the possession order is higher and the relinquishment is lower, it seems that relinquishment orders actually track what is checked off in the petition. So if we'll go to the next one here. And that's what we found in the data. Okay, so I'm sorry, I only have 2 large tables left, but if you'll bear with me for a moment. Let's look at the row for 2023. What I'm doing in this table is I'm trying to connect a final PFA all the way through retrieval. So in 2023, there were 10,688 PFA orders. Of that 10,688, in column 2, 5,326 had a caution. 5,326 of those cases had the caution in the petition. Okay, moving to column 3, of these same cases, 5,326 of those PFAs also had a relinquishment order. Okay, so a relinquishment order is more closely tied to the indicator in the petition. So in column 4, I have the ratio of relinquishment orders to petition cautions for relinquishment. So while in the previous one I mentioned, well, shouldn't 100% of PFAs also have a relinquishment order? And that wasn't the case, but it is the case here. 100% of cases, give or take, of PFA orders where the petitioner checked off that we would like a weapons relinquishment gets a relinquishment order. Okay, so that's columns 1 through 4. It's a bit messy, but we're struggling through it. Let me add on a little bit more here. Of those cases that got the relinquishment order, we also have the retrievals from the PFAD data, which is in column 5. And that leads to column 6. This gives us the percentage of relinquishment orders that were actually retrieved. Okay, so in 2023, that was about 80%. Now, we don't know why that's not 100%. Is it that it could be for a variety of reasons, not all of them necessarily indicative that guns are not being, or firearms or weapons are not being actually retrieved. It may be that they weren't there in the first place because it might have depended on the petition. So we don't know why that's not 100%. One thing I would want to point out here, if we look at the growth rates, and there's a little bit of a difference in the growth rate in column 3, which is the growth rate of relinquishment orders over time, that's gone up by 42%. Okay. If we compare that to the growth rate in retrievals, that's a little bit lower at 36%. One thing that I wanted to, that difference was striking to me because you would think it'd be about the same or at least closer together. But it could be indicative, and it's something as an economist I want to always keep my mind of. Do we have resources to do these extra things? And knowing that local departments have real resource constraints, with the strong growth of relinquishment orders, do local agencies have the resources to keep up with actually doing the retrievals? That is just speculation. And part of our speculation, I want to make sure that we know this. Part of the reason we're doing the qualitative work is to see if these discrepancies in the data, is it that relinquishment orders are growing fast and it's hard for agencies to keep up in actual retrievals? We want to find that out in the qualitative data. So the qualitative data will help us confirm what's going on here. Next slide. Okay, this is the last table. So congratulations, everyone. We've made it through. Just a one thing I want to point out here. Again, we're breaking down cases. These are all cases that ended with a final PFA, both a final PFA and a final relinquishment order. And so this is breaking down retrieval rates by whether the final PFA was by hearing or agreement. And so we'll look at the first two sets of columns just to keep it brief. In 2023, the retrieval rate for among PFAs that ended in a hearing was 80%. And it's slightly higher if we move over 2 columns to final PFA orders by agreement. Okay, across our 4 years of data, PFAs that ended in agreement had higher retrieval rates. So that is something for us to keep in mind. That's another thing that we would want to look into more closely with the qualitative research to know what's going on here. Danny, I believe, wanted to address some of the questions most related to what our findings were here. So I'll pass it to Danny for a second.
Yeah, thank you so much, Brandon. So we wanted to sort of address at least 2 of the questions, as Brandon said, related to these retrieval rates that were asked of us ahead of time. And one of the first one we had is, how do we best combat the relinquishment of all firearms when dealing with PFA orders? And, the person asking the question described that this is an issue prevalent in rural areas where individuals are avid hunters and may have multiple firearms located in several different locations. So to address that, to put it most simply, the only way to know if all of the firearms that are within the defendant's possession and control have been relinquished is the way that most folks would suspect is to obtain a search warrant and to search the defendant's home for the suspected firearms. However, that kind of gets us into the criminal realm. Probable cause may be difficult to obtain. And again, if that survivor is sharing a residence with that abuser, they could be wrapped up in, anything that's in plain view or, other things that may be found during a lawful search of the residence for firearms. So one way we often work with folks to getting this kind of information and making it most accurate is if the defendant is present at that final order hearing, the court itself can inquire, or the plaintiff or their attorney can ask the defendant where all the firearms or rifles are located, and they could do that on the record. And then what is also to memorialize it, in addition to having it being read into the record, is making sure that that information is added to the attachment A, which is the form that lists all the weapons that the survivor knows the defendant may have control of. So that is one way to work around this. And we're, another question that we had is very related to this. It's been difficult to get law enforcement to relinquish weapons if they are not picked up when that PFA is served. So, they are not going out again. They're just going out to serve the PFA, and the defendant is not directed to bring them into law enforcement. So what advice do we have to get law enforcement back out to either pick up the weapons or to follow up on that relinquishment? So this is really why we stress and why we say it's so important that when law enforcement is working within PFAD, that even if they are getting non-compliance notifications for a failure to relinquish, to either investigate, or that the defendant has not relinquished their weapons, there is a button to disable non-compliance. But it's so important to stress that this button is almost never pressed or selected on PFAD to just stop receiving the notifications, because in reality, law enforcement is required to enter a receipt of relinquishment whether they receive all, some, or no firearms. And that button is not meant to be selected to just stop receiving the notifications. And we are here too at PCADV, and PSP helps us too to sort of help encourage agencies to communicate with one another on these cross-jurisdictional relinquishments. A lot of times PSP will use police communication officers to check in on what the situation is, whether stuff has been entered properly, or has been, effectuated but not yet entered. But really, the law states and PFAD procedures state that someone needs to go out and retrieve the weapons if the defendant has been ordered to relinquish. And they need to put a relinquishment receipt into the PFAD system within 24 hours. Otherwise, the notifications will continue and still need to continue. And this is not just the advice that we provide to law enforcement agencies at PCADV, but this is advice that we receive from PSP to communicate to law enforcement agencies. So there is these responsibilities that are placed on them both under Act 79 and under, them using PFAD and, signing the terms of use. So hopefully that answers some questions folks may have around some of the practical ways to ensure that weapons relinquishment is performed correctly. And I'll turn it back over to Brandon to cover this next graph around retrieval rates for weapons inventories.
Thank you, Danny. So one thing I just want to highlight before proceeding is this is all correlational data analysis. It is not indicative that if you do something in the petition, it's going to lead to a given outcome. We just wanted to find within the data where things are linked a little bit more. Okay, where things are associated across the life of a case. So what this slide is looking at is just those cases that ended in a final PFA and a final weapons relinquishment order. But those cases started with petitions, and sometimes those petitions also had the attachment A weapons inventory with it, okay? And what we found is when the inventory is included in that initial petition, you get much larger retrieval rates at the end of the case if it ends in a final order. Okay, so that's what we see here. 84% of the cases that started with a petition with the inventory included ended with a retrieval rate all the way through the life of the case. At the end of the life of the case with the data we have, 84% of those ended with a successful retrieval. Comparing that to only 77% of initial petitions that did not have the inventory included. One thing that we noticed also, again, across the state, if we broke this down, both retrieval rates and the percentage of petitions with this inventory included varied widely, as with everything else in the data, right? Every county is doing something different than the other counties, but this is the overall aggregate. And my last set of graphs here, one, if you can skip over to the next slide, please.
Brandon, I think we had a question related
Oh, yeah.
to.
Oh, I'm sorry. I'm sorry. Yes.
Sorry
yes.
about that.
Back
No,
to you,
that
Danny.
was my responsibility to jump in there, but no worries. So again, the question that we had kind of begets the two questions that we just answered, which is a lot of folks are probably thinking this is, what about cases where a victim is unsure of the exact type, quantity, or location of firearms owned by the defendant, and what steps can be taken to ensure full compliance with Act 79's firearm relinquishment requirements? Are there best practices for gathering this information or addressing potential gaps in disclosure? So we want to start with that, really outlining that this responsibility is on the victim, is on the survivor of trauma, is on the survivor of domestic violence to provide this information. So of course, there is going to be concerns about potential gaps between the trauma and also the fact that they just may not know that what all weapons are within the defendant's possession and control. So some tips that we use and we've worked with advocates in using to help ease this burden on the survivor and also get the most accurate information is, in some areas, the advocate and attorney can take the plaintiff to the sheriff's office, when you're, after the PFA has been ordered, or when they're, really being able to compose that attachment A, and have the deputy assist the victim in describing the firearms and rifles and where they may be stored. The more clearer description, the better. If the individual who is defendant keeps a shotgun next to the back door to the porch and keeps it there all the time, we want them describing a large rifle or shotgun, if they could describe it as best they can, that, is typically kept next to the back door to the residence, at all times. We want them describing the physical weapon and the place. And advocates and attorneys who are trauma informed may be able to assist the victim in remembering what the defendant has, working through the stories, the incidents of abuse, where these guns and rifles are stored, and asking the victim if anybody else has seen the guns, smaller communities, hunting partners that may have, went out with him or her and seen what they own, or, have went to a range with them and seen weapons that they own. If it is safe to speak with the person, we suggest it to try and get that information so that you can have the most accurate accounting of what weapons, are at risk for the defendant using against the survivor. So I'll turn it back to Brandon to cover that last graph that we were going to go over.
Thank you, Danny. So this breaks down what happens in the retrieval phase. And so we do have indications of both how long it took and then by the department that did the retrievals. So the first two circle graphs we have here are indicating, okay, when the case ended with a temporary order only, sometimes there was a relinquishment order at the temporary phase or around that phase. Sometimes some cases might have multiple temporary hearings. So what we see with the blue graph here is that 57% of these cases where there was a relinquishment order, 57% were same-day retrievals. And then 28% there was no retrieval, and 13% actually happened before, perhaps due to a previous temporary order. Okay, so the non-retrieval rates go down as we shift to the orange graph, which is for final orders. Okay, final PFAs, final relinquishment orders, what's going on with their retrieval times. 30% of those happened before the final order. Okay, so they might have been retrieved within the temporary phase or between the temporary hearing and the final order. 48% of those were same day, 4% were after. And again, like I've said, we've already looked at how there's non-retrievals. So 18% did not indicate a retrieval in the data. The last pie chart indicates which agency was doing it. So 65% across the state, again, this is statewide aggregate, was by sheriff's departments, 13% by local PD. And again, this varies widely across the state. So we did have another question pre-webinar. Are there any issues with law enforcement ensuring compliance with an order, temporary or otherwise, requiring relinquishments of weapons or filing verification of the same? Now, we hope to learn more about this through the qualitative work. What if any issues may be. I mean, it may be, is it an issue with actual retrievals, or is it an issue with data entry into the system? What we do know, again, is that counties varied widely in both the retrieval rates, in the time to retrieval, and the department that was doing the retrieval. So we did learn some of that from the data, but we are certainly hoping to learn more as we continue this research. Now, putting it all together, and again, thank you for staying with me during all of our tables and all this data. It's been quite a ride putting this all together and trying to keep it in something that we can take forward. Again, this is correlational data. It's not indicative of, if you do something at the petition stage, it will definitely lead to an outcome. We're not saying that, but within the data, there are some things that we noticed. Okay, so what I did is looking across all cases. There were two things that come out at the petition stage that are associated with either the case ending with a final PFA order or the case ending with a final relinquishment order. And there are two things that I already mentioned. Two things at the petition stage is, one, when you check the weapons order caution in the petition, those cases have 1.5 higher odds, 1.5 higher odds of resulting in a final PFA order. And they have over 90 times the odds of resulting in a final weapons relinquishment order. Okay, remember the graph that showed 98% of those petitions that have, where it's checked off that there's a weapons order caution. They almost always end up in a final weapons relinquishment order. So that's the first thing in the petition. Checking that off has strong association with final orders. The second thing is including the weapons inventory with the petition. And similarly to above, petitions with a weapons inventory have higher odds of resulting in a final PFA order and 100 times the odds of resulting in a final weapons relinquishment order. And again, it's not now, this is after the case has gone through every stage where it's either been by hearing or agreement, but these are two things that we found strongly associated with this. Surprisingly, in the petition, you can also check off whether a weapon was present or a weapon was involved in the incident. And those two checks are not more likely to result in a final PFA order. Okay, so the weapons order caution does, the weapon inventory, those are both highly associated. Again, statistically, it's not saying that it happens all the time, but it is something that we should take note of. Okay. So I'll turn it back to Danny here. Again, thank you for listening to our results, and we are always open for questions. Thank you.
Thank you so much, Brandon. And I'm just going to try and give some takeaways that we've had as practitioners, those of us who have represented survivors or work with folks who have assisted survivors, and take a lot of the data that Brandon had and put it into some of the things that we've seen that this data may point to. So the first thing we've obviously recognized is plaintiffs' requests for weapons relinquishment at the petition phase of the process are highly influential as related to final PFA orders that include a requirement that weapons be relinquished. So again, if, seeing this correlation, seeing this relationship really is, I think, making folks be cognizant of the fact that weapons relinquishment is a form of relief, and that, the sooner it is requested, the more likely it is going to be part of a final order or a longer standing order. So the rate at PFA filing increasing at a slower rate than the increase in requests for and inclusion of firearms relinquishment orders may point to an increased awareness of the danger of firearms relief and danger of firearms and the relief available under PFA, under PA law. So this, we kind of are seeing, this kind of shows us that folks are aware of Act 79. Not only are they aware of Act 79 and its ability to keep themselves or the survivors they work with safe, but they are aware of the serious and substantial risk that having access to a weapon, or specifically a firearm, poses to that survivor and their children. Latest data from national studies have shown that if a survivor is in a household where they have access, where the defendant has access to a firearm, the chances of them dying at the hands of that firearm increase more than 1,000%. And possibly, this increase in requesting this relief not only shows that the law is something folks are aware of, but also the danger of not having those firearms relinquished and having them still in the defendant's possession poses to them and their family members. One thing that we found very interesting in comparing with some other data that we've seen in work done across the state is the decrease in consent agreement rates may be related to the increased firearms relinquishments, given that the latter's increase was at a greater rate than the increase in PFA filing over the same time period. And this really is, we're also looking at some similar trends, also address some of the concerns raised in other reports, specifically one that was done by the Administrative Office of Pennsylvania Courts in conjunction with the Center for Court Innovation, now the Center for Justice Innovation, that, showed that in Pennsylvania, there is a over-reliance from the court on consent agreements to resolve PFAs, given that oftentimes these agreements may not be always the most suitable type of way to resolve a highly contested PFA action, and may not account for all the safety concerns the petitioner has. So seeing the decrease in the consent agreements may suggest that more folks are choosing to go to a final hearing because they are choosing to, make sure that the defendant is ordered to relinquish these weapons, that there is no, choice in the matter, that the court is pushing them and requiring them to relinquish the weapons. And then again, one other thing we've seen, and I think this always sort of begets when we look at data and increased awareness of legal actions and ways and forms of relief, is there are growing opportunities for education, training, and technical assistance around Act 79 so that we can help strengthen the protections provided and improve consistency of the implementation statewide. Reduce the fact that things seem to vary from county to county, and, have that consistency across the counties and across the state in implementing the changes under Act 79. And I think we think there's a lot of opportunity to do that. That's been shown in the data through education, training, and technical assistance. And before I turn it back over to Lindsay, I wanted to just answer a quick question that we did get prior to the webinar, which was around, does Act 79 or weapons relinquished have any impact on the defendants living in a household with others who can legally own a firearm? So if you are that person who is living in the household with a possible PFA defendant that has been ordered to relinquish and you legally own a firearm, you should be worried that that firearm may be ordered to be relinquished because it is included on the attachment A. It is not just the firearms that the defendant owns or has registered in their names. It is all firearms within the defendant's possession or control. And we, again, are relying on the survivor to give us the list of weapons And it isn't reasonable to expect that the survivor is going to know what firearms they've seen in the house and who specifically owns this one and what ones are registered to the other person that isn't the defendant in the case. So we also do have provisions and procedures under the PFA Act to return weapons to a third party should they be ordered to be relinquished under a PFA. But this is something that I think folks who are still legally allowed to possess need to be concerned about if a member of their household is ordered to relinquish, that their firearms may be listed on that attachment A and be part of the firearms that need to be submitted to a third party for safekeeping during the pendency of that PFA. So I will turn it over to Lindsay to answer another question that we got before the start of the webinar and to take it away for the rest of the slides. So thank you so much.
All right, thanks, Danny, and thanks all for bearing with us. I told you at the start we'd go about an hour, give or take, and I guess we're taking here because we're approaching an hour and a half. But I'm just there was one more question that didn't fit great, within the presentation that I'd like to address, and then I'd like to give Elizabeth plenty of time to talk about the next steps here. So the one final question we have is whether or not there's any data related to the reduction of shootings in relation to the increase in relinquishment of weapons. And at this point, the answer to that question is no. I mean, when you think about the shootings broadly as a term, it would be very difficult data set to try to get shootings across the Commonwealth of Pennsylvania. What we do know is based on research, and we know that research done by the RAND Corporation evaluating gun policies to address homicides and other violent crimes does suggest that there's moderate evidence to support that prohibitions on weapons associated with domestic violence can reduce intimate partner violence. Unfortunately, we also know from PCADV's 2023 fatality report that 3/4 of domestic violence homicides in Pennsylvania involved firearms. And while overall number of homicides statewide decreased in 2023, the number of domestic violence homicides increased by 14%. So unfortunately, we do not have data at this point that indicates a reduction in shootings. Again, shootings broadly, we would not be able to get data on, but we are hopeful that these types of laws and policies will help over time. And so, as Brandon mentioned throughout his portion of the presentation and talking about the statewide research we've done, a lot of those data points vary county to county. And so we've started working with Temple University on some qualitative research, and I'll turn it over to Elizabeth to discuss that.
Thanks, and I'll be very brief. So our study is relatively new. We began in October of 2024 and will conclude in September of 2026. So I don't have any findings to share with you, but what we're going to do is to expand upon the excellent research that was done with Brandon and his team from a quantitative viewpoint. In our study, we're trying to answer the why. Among other questions, we're going to attempt to figure out why there are significant differences among Pennsylvania counties regarding the prevalence of protection from abuse cases, the percentage of cases that end with a final PFA order, the percentage of cases with relinquishment requests, the percentage of final orders and consent agreements that include a weapons relinquishment order, and also weapon retrieval rates. We're going to use what's called a multi-site, qualitative research design to evaluate how a subset of local Pennsylvania jurisdiction implements and enforces Act 79. So first, we identified 8 study counties from across the Commonwealth. And we wanted to get a good mix of counties regarding urbanicity versus rurality, political leanings, population size and makeup, as well as variances in Act 79 implementation. So we're currently in the process of accessing data from 3 main sources. First, we're gathering procedural documents accessed from courts and court websites in our 8 study counties, and I'm glad to report we have completed that task. Next, we'll be conducting court observations of PFA hearings, and then finally, we're going to be conducting interviews of key stakeholders in those 8 counties, including judges, sheriffs, victim advocacy groups, and survivors. Next slide, please. So once we code all the data from the 3 data sources using a software system called Atlas TI, we're going to use what's called triangulation to analyze the data. And I won't go into a lot of detail, but basically triangulation in research has benefits. Insofar, it improves the credibility and validity of findings, and it can also mitigate any biases which can be present in qualitative research. Our research methods will allow us to evaluate how each county implements and enforces Act 79, including socio-demographic characteristics, local conditions such as resource allocation, local differences in local procedures and practices, factors that affect full compliance with implementation, and perspectives from those responsible for implementing or enforcing, as well as perspectives of individuals whose safety is contingent upon the effective implementation and enforcement of Act 79. So between site analyses, we'll explore similarities and differences and insights from comparisons, as well as support the development of themes. The second within site analysis will look at patterns that are common across all sites. Next slide, please. And then finally, the results of our project will be used to draft recommendations that can be used across the Commonwealth, as well as in other states with similar laws or with states that may want to implement similar provisions. We're going to be preparing a report with a summary of key findings that will share recommendations with lawmakers with whom we have established relationships. We're also in the process of developing a website that's going to be dedicated to the project, which will serve as a central repository for project-related materials, including a one-page infographic that will be shareable. We'll also disseminate findings through a variety of avenues, including academic papers, blogs, conferences, websites, or webinars, and the like. So we really look forward to sharing our findings with you, and thank you very much for your attention today.
All right, well, thanks everybody for joining us. Thanks to those of you who stuck with us till the end here. On the slide in front of you, I have our emails for each of the presenters who we heard from today. And you'll be, please feel free to reach out with any additional questions that maybe we didn't get to during the presentation. And just as a reminder, we will be posting the recording, posting the slides, and sending that information out to the folks who we have emails for. So thanks again for joining us, and we hope you learned something today.